All right, Dr. Singh, you are always very precise. You are always very precise. Now go on to the next point.
Your Lordship's compliment is intended to render me speechless. Well, I'm not going to be
No,
speechless.
no. No, it's not
Allow
like
me,
that.
Malas, a
Dr.
few
Singh,
minutes.
there is too much. The point is,
This is,
there is a lot of stuff that we have to reflect on now, and we just want you
so
to now
maybe your Lordship will just
in
give a little over
rapid
4
fire
o'clock.
summarize it for us so that we can have.
Let me speed along, and Malas, your Lordship may give me a few minutes after 4 minutes. See, I am very keen to finish, Malas. I'm not, till now, Malas, I have not repeated a single point. I've given your Lordship a new facet.
Now not interrupt you. Go ahead.
Yes. I can't be saying I'll topple first and then I'll apply to EC.
So remain a member, be a part of it, and
Malas,
contemporaneously.
vindicate your principle. Absolutely. Malas, I just see the reverse of it, but just consider how it will apply. You first topple the government, then you go to the EC. And why did you like the 10th schedule?
That we understand.
No, and Malas, also, apropos my Lord Chief Justice query, Malas, are you harmonizing or not? Malas, one more thing. The fact that you don't choose consciously not to exercise an option does not mean you can wish away the option. The option is a constitutional option. It's a constitutional option. It's as equal to split as it was earlier. You don't exercise it, it really amounts to saying this, I want to avoid the 10th schedule. So I will put blinkers and close my eyes to 4 options available. 4 constitutional options, the 5th one is deleted. And I will choose a new option, which is only the 3-step procedure. First, disable the speaker. Second, approach the governor. Third, be sworn in.
See, the negative prohibition in the 10th schedule is twofold. One, voluntarily giving up a membership, and 2, defying a whip, 21A, 21B. The 10th schedule certainly does not have any provision by virtue of which there is a prescription if you do not give voluntarily, if you do not give up the membership of the party, and yet exercise the right of working your remedies within the party.
Then you cannot be held to be a defector.
Right.
And that is the whole purpose. You were elected.
That's exactly the case, no?
No, but Balas, then in that case, why did you enact the 10th schedule? Balas, 10th schedule is not Balas saying that Balas, Article 19(1)(a), just see 194, Balas, very interesting article. It is not saying, let me put this harmonization, which is a very important principle, in another way. What is the scheme of this entire system? Well, if your Lordship were to make a standard as broad as if you have a dissent, you can violate the 10th schedule, then your Lordship is unmanageable.
But your
Unmanageable.
argument, Dr. Singhvi, would be,
Yes.
the extreme argument on this side, which possibly you can adopt also, is that any dissension amounts to the voluntary giving up of the membership of a
No,
party.
I'm going to give Malas more. I'm not extreme. The other argument is extreme. I'm going to give a harmonized answer. Immediately to that, the principle can never be Malas dissent. I'm not happy, therefore I can go. 3 answers, Malas. 1, everybody has dissent, Malas. Which political party? There are enough inbuilt outlets within the party to express dissent. 1. That is what your Lordship will always say. 2. The dissent within the party at the appropriate fora can be followed by any of these 4. 3. You, Malas, if you are having dissensions and you are not satisfied with the party system, then Malas, you will simply express it that I am resigning or doing Malas, going away with 9/10 of the people. But Malas, how will you say that mere disagreement entitles me to topple? Here they have not expressed dissent. Well, this is not a case of dissent. I have not gone out and spoken against the party. Dissent plus, this is dissent plus. Dissent plus toppling. Your Lordship remembers I started, I think during the Navam Revia hearing. Your Lordship notices 191(2) and 194. Your Lordship may not remember that, but just kindly turn to that for a minute. 191(2) is a clear statutory, constitutional prohibition in the 10th schedule saying you shall be disqualified. That's the 10th schedule comes from 191(2). Now, 194, which follows 2 clauses later, says, subject to the provisions of this constitution, there shall be freedom of speech in the legislature. And 19(1)(a) is even more reasonable restrictions. Now, it can't be that mere saying free speech, I can violate, I'll violate, you can act within the party constitution. Whatever the party constitution allows, some party constitutions have even appellate bodies, some have 2-level things. You can actually do all of it. Before you go by these 4 escape routes of merger, resignation, you can do all of it. But ultimately, if it doesn't work, you have to take these 4 routes. And 194(1) makes it clear, subject to the provision of this constitution and to the rules and standing orders regulating the procedure, there shall be freedom of speech in the legislature of every state. This is not more as an open-ended charter. And plus, kindly see the consequence.
Dr. Singh, according to you, when does the governor then order a trust vote?
No, the governor has no role at all in such a situation. Governor, first answer your lordship is when the government is formed, or when the government is about to be formed. That's the inception argument. The governor will never come into a 10th schedule situation. It's what is your lordship considering? An intra-party dispute. At the end of the day, what is this dissension? I don't like you. I don't like you. Intra-party. How does it come to intra-party dispute? How does it even recognize it? There are all kinds of feuds going inside parties. How does my lord lay down in English language a judicially manageable standard to control the governor peeking into intra-party disputes? It will be the thin end of the wedge. This is nothing but political party A intra. The governor will deal with some constitutional issue or something relating beyond intra-party. And how will the governor deal without any specific article, mind you, Manas? In a sense, superseding and overdoing the 10th schedule, which is a constitutional article, with 191(2), which we tend to forget. 191(2) read with the 10th schedule.
The couple of things. Step 1 was, as we saw, the three steps that you told us. Just
Yes,
1 second, I'll just go back to it.
Correct, Manas.
Notice of removal to the speaker,
Yes.
resolutions given to the governor, and the act of being sworn in as CM.
Correct.
There's one step earlier, probably one step which you can also add there, which was the governor's trust vote communication.
I'm grateful, Manas. I'm grateful.
Right. Now,
4-step
there,
procedure.
suppose, notice of removal of the speaker, we are not really called upon to adjudicate upon the validity of the. क्या हो गया? तो क्या है भाई?
You said 3 o'clock, so they can.
नहीं अभी टाइम है जाओ
No.
फिर क्या ना
Except in Navam Rebia. Your lordship, if your lordship chooses to refer, would have that issue. Navam Rebia,
if we choose
in the broad, no, I'm saying it arises. I'm not saying your lordship may have to for this case. I'm saying that's the core issue.
of course
No, I'm saying, Manas, it's an issue. which
the governor asked for a trust vote.
Yes.
Two ways of looking at it. While the governor had material to call for a trust vote, in which case a further issue would arise as to whether he was justified in calling upon Shinde to form the government.
Pinpointing, picking out a person and saying,
Picking out a person, because
correct.
even assuming that the governor had material to call for a trust vote, what is the basis for picking up Shinde? Second, that the governor had no material to ask for a trust vote. That there was no valid material at all
That's a
on the
core
basis of those three circumstances.
That's a core question. And Manas, that goes to the heart of the matter. If I may digress for 30 seconds, Mr. Tushar Mehta was right when he quoted the couplet, but perhaps didn't realize that the second sentence applies against him. He quoted Bashir Bhadra to say, "चुप रहे तो गलत फहमियां और भी बढ़ी, उसने वो भी सुना जो मैंने कहा नहीं." उसने वो भी सुना जो मैंने कहा नहीं. Well, the governor in his letter at 326 PDF talks of a resolution to exit the government, which doesn't exist at page 55 of the resolution itself there. So he's hearing things jo kaha
The
nahi.
resolution doesn't say that we are exiting the government.
Yes. So he heard something.
We had wanted to.
Well, I found a more appropriate one for Mr. Mehta. I found a more appropriate phrase for Mr. Mehta, not Bashir Bhadra.
So really, question was whether there was a valid exercise of power by the governor to call for a trust vote. And but what happens if we come to the conclusion that there was no valid exercise of power by the governor to call a trust?
Everything false.
Everything false is very.
No,
very
I'll be dealing with Bomai. That's the core question. your lordships is saved a lot of unnecessary exercise if your lordship comes to that conclusion plus follows Bommai, which in any case is
So
9
then
years.
you, according to you, what? We reinstate the Uddhav
Just
Thackeray government?
straight away, let me first change my tack and go to Bommai.
But you resign, no?
No, that's, I covered in my note directly. 5 reasons. Justice Shah asked me that one in the beginning, your lordship asked me that, I'll straight away answer. That is actually red herring. My resignation and not facing the trust vote is irrelevant. Completely.
But that's Ms. Dr.
No, Malad, I'll deal with it. So let me deal with it.
Because
So let me deal with that.
if you, it's like the court being told that you reinstate a government which has
No, Malad, it's
the acknowledgement by you.
I hear your lordship loud
And you
and clear.
resign.
It's a question asked earlier and it is actually a plausible looking thing, but it's actually irrelevant. I'll show that in a minute.
No, Mr. Kapsil, how can, just hypothetically,
Yes.
how can the court reinstate a chief minister, correct, who did not even face the floor of test?
Your lordship is not reinstating anybody. Your
Then what
lordship
will,
is
what will be the
restoring-
consequences?
Your lordship is and should and does, and Bommai says it more graphically, restore status quo ante.
We
That's
would.
the meaning of a.
But Ms. Dr. Singhvi, it would have been a logical thing to do. That's where we are, it would be a logical thing to do, provided you had lost the trust vote on the floor of the assembly.
Lordship may just flag that. I mean,
Right,
I
because then clearly you have been ousted from power because of a trust vote which is set aside.
correct. Duty bound to satisfy lordship, and I believe that.
Right. Now, our problem is, look at the intellectual conundrum.
Yes.
That it's not that you have been ousted from power as a result of a trust vote which was wrongly summoned by the governor. You chose not to, for whatever reason, you didn't want to face the trust vote.
I
and
face
that's
that
what
squarely.
is-
Allow me, Malus, I'll change my sequence and come to this first right now. May I, Malus? Because straight away your lordship's conscience should be satisfied. This is a red herring. It should not deter, will not deter in law your lordships. If your lordships comes to the conclusion of the other one. Give me just 5 minutes on this. May I end the first part, Malus? That is, Malus, this affirmative and negative code.
Yes, that you
With only one,